Welcome. Today we're going to discuss a recently decided case by the U.S. Supreme Court that has created groundbreaking implications for companies looking to trademark their generic.com brand. My name is Scott.Slavick. I'm the co-chair of Barrick's Intellectual Property Group, and I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, or searching and clearing new global brands on a rush timeline, or reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. The case I'll be going over today is the United States Patent and Trademark Office versus Booking.com. Booking.com is a digital travel agency specializing in reserving hotel and other lodging accommodations. In 2011 and 2012, the company sought to federally register Booking.com for hotel reservation services with the USPTO. The USPTO denied the Booking.com applications under the long-standing rule that generic words, the name of a class of products or services, are not eligible for federal trademark registration. The USPTO's Trademark Trial and Appeal Board affirmed the rejections, concluding that Booking.com was generic because consumers would understand its primary significance as an online reservation service for lodgings generally. Booking.com sought review of the USPTO's decision in the U.S. District Court for the Eastern District of Virginia, but lost again. The U.S. Court of Appeals for the Fourth Circuit heard the case, but also agreed with the USPTO. Ultimately, Booking.com appealed the case to the Supreme Court, where it was heard in May. In this case, the USPTO and Booking.com argued over whether a generic term with a .com label behind it could be considered distinct enough to trademark. For their case, the USPTO relied heavily on two main arguments. The first argument was that the Trademark Manual of Examining Procedure, or the TMEP, states that to be registrable as a service mark, the asserted mark must function both to identify the services recited in the application and distinguish them from the services of others, and to indicate the source of the recited services, even if that source is unknown. USPTO attorneys argued that a generic word such as booking, followed by a .com label, could not uniquely distinguish itself from other similar services in its field, and thus it did not fulfill the requirements for a mark. To bolster this claim, they moved on to their second argument. This argument relied on a previous Supreme Court ruling in the case of India Rubber Glove versus Goodyear Rubber Company, which held that the combination of a generic term with a corporate designation like company or Inc. did not create a protectable trademark. They emphasized that the principle that generic terms cannot be protected as trademarks is long-standing and fundamental. For that reason, courts have long held that evidence that seems to show that a generic term has acquired secondary meaning will not allow the term to be protected as a trademark. Further, the USPTO attorneys argued that if generic.com trademarks were securable, it would be easy for a generic.com business to generate a survey that proves that a significant number of consumers associate any domain name with a specific business, even if the consumers are not familiar with that business. That would allow online businesses to monopolize generic terms, even though they would not be able to do so for an equivalent brick and mortar business. Attorneys on behalf of Booking.com also took a two-pronged approach. They first argued that when Congress passed the Lanham Act, it overrode the precedent set by the 1888 Goodyear case. The Lanham Act, they argued, now established a rule that asked what consumers believe that a term signifies. The statute tells trademark examiners in the courts to determine whether a term is generic by examining the primary significance of that term to consumers, allowing consumers to decide which terms merit trademark protection. Following this logic, Booking.com submitted a consumer survey as part of its evidence, showing that 74.8% of consumers associated its name with the company specifically. For their second argument, Booking.com claimed that a trademark was necessary to ensure business protection. They rebutted the USPTO's claim that granting generic.com trademarks would allow for online monopolization, saying they expressed no interest in suing any other company that used a similar domain name. Instead, they argued that a registered mark would provide the company with a weapon against counterfeiting, fraud, and cyber piracy. Booking.com argued that it needed trademark protection to prevent competitors from opening storefront Booking.com travel agencies or from diluting its brand by selling Booking.com themed travel products in airport shops. Ultimately, the Supreme Court sided in an 8-1 decision with Booking.com. The court held that a proposed mark comprising a generic term coupled with .com is not automatically generic, but may be registrable provided that consumers perceive the mark as a source identifier. Justice Ruth Bader Ginsburg, who delivered the opinion of the court, summarized, because Booking.com is not a generic name to consumers, it's not generic. In her decision, she also cited the district court's determination that Booking.com was both descriptive and had acquired secondary meaning as a hotel reservation service. Finally, Justice Ginsburg noted that the USPTO's own history for granting marks was not in line with their argument, citing their decision to previously grant trademark status to art.com and dating.com. The court's 8-1 decision held that adding .com to a generic word can make the entire combination eligible for trademark protection. While the court's decision seems like a win for brand owners, the court's holding may create more uncertainties than it resolves. The landscape of trademark law might be greatly impacted by the now prevailing rule that ever-changing and difficult-to-measure consumer perceptions will, on a case-by-case basis, govern the registrability and enforceability of each generic .com mark. The resolution of the questions explored below and several others will define the legacy of the court's Booking.com decision. First, how will the USPTO determine whether the combination of a generic term and .com or .net or .org yields additional meaning to consumers capable of distinguishing the goods or services? Notably, the court was careful to clarify we don't embrace a rule automatically classifying such terms as non-generic. Accordingly, because the eligibility of a generic .com mark for registration will almost always require close and careful evaluation of acquired distinctiveness evidence, a tribunal of TTAB judges, rather than a single examiner, will likely initially set the standards for registration. Because of the potential ramifications of granting a generic .com registration, most trademark practitioners will welcome the scrutiny of 3 experienced trademark judges in the process. Over time, however, TTAB decisions become examination guidelines for individual trademark owners. So it remains to be seen if and when trademark examiners will be able to approve generic .com applications on their own. Second, will the decision lead to the proliferation of generic .com marks? Even though the court left open the possibility of registering generic .com marks, there is no question that applicants will face a costly uphill battle to overcome the presumption that the applied for generic .com mark is not registrable. In addition, the Trademark Office's records are publicly available online, and there's no way to submit evidence of acquired distinctiveness, typically sales and advertising data, under seal. Many companies consider this data commercially sensitive and will hesitate to make this information publicly available, at least until it can qualify the value of generic.com registrations vis-a-vis the business risk of the disclosure. Third, even if an applicant secures a registration for its generic.com mark, will the registration be a paper tiger, appearing powerful and threatening but ineffective under the scrutiny of litigation that primarily serves vanity purposes? Will it block third parties that apply for composite marks incorporating the generic term as an element with a disclaimer? Only time will tell if the Trademark Office, TTAB, and federal district courts will handle the Herculean task of defining the exclusivity afforded the registration of a generic.com mark. The court acknowledged 2 hypothetical conflicts raised by the Trademark Office vis-a-vis Booking.com, eBooking.com, and HotelBooking.com, but failed to offer any insight as to how such conflicts should be resolved. Nevertheless, the threat of trademark litigation is a powerful enforcement tool. The court suggests that concerns with over-aggressive enforcement of generic.com registrations are mitigated by classic fair use principles and long-standing jurisprudence that conceptually weak marks are entitled only to a narrow scope of enforcement. The court's reliance on these counterbalances is perhaps naive, as the economic reality of trademark litigation, read onerous fees and costs, often precludes a defendant's vindication of its rights. Even for defendants able to withstand the financial hardships of trademark litigation, the applicability of a classic fair use doctrine is somewhat limited by a general requirement that the alleged infringer not use the disputed element in a source identifying manner. Accordingly, after a trademark applicant has invested heavily in obtaining its generic.com registration, it has every incentive to build a halo around its registration. Fourth, what elements can be appended to a generic term to create a composite that may be registerable? It seems that any generic top-level domain, .net, .org, could replace .com in the generic.com formula, but creative brand owners will likely seek to apply the court's decision to an @ sign, the hashtag sign, 1-800, and other combinations. The court's decision leaves open the possibility that any combination by which consumers can distinguish the applicant from its competitors could be registerable. Fifth, will the Trademark Office require applicants for generic.com marks to prove their ownership of the corresponding domain name? What will happen if the applicant registrant no longer owns the domain name? Finally, for the lion's share of brand owners that have taken advantage of the fact that .com is essentially ignored for trademark purposes, will their strategies need to evolve? For example, under the Uniform Domain Name Dispute Resolution Policy, the UDRP, the addition of a generic top-level domain name to a brand, i.e. brand.com, does not typically mitigate confusing similarity with the brand. Likewise, the Trademark Office has typically allowed trademark applicants and registrants to freely amend their applied for or registered marks from brand.com to brand to brand.com, and brand.com to brand.org, without having to file a new application and/or reestablish priority. Will the arbitration panels deciding UDRP disputes modify their prevailing views on the significance of .com? Will the Trademark Office revisit its guidelines for amendments involving generic top-level domain names? These possibilities will likely affect more brand owners than the rare exceptional circumstance in which a brand owner secures a generic.com trademark registration. The court's decision in USPTO versus Booking.com will ultimately lead to a new area of trademark law that will greatly change how and what protections generic.com terms will have. If you have any further questions or are interested in possibly protecting a generic.com trademark, please feel free to contact me or any of the Barrick lawyers that you typically work with, and we'll be happy to help you.